welcome to our land law and conveyancing lectures. And I recognize some of your faces, but many of you are new to me. So maybe in the first year you have not studied with me about law of obligation. So maybe I'll introduce myself first. I'm Tommy Ho. I am working at Space. At the same time, I'm also a practicing barrister in Hong Kong. Because I do not work full-time in Space, so my usual practice is that I will leave my email to my students. So if they have any question, or if you have any question in relation to the lecture, you can always drop me an email. The email is very simple, tommy.ho at hkuspace.hku.hk. And usually I would try my best to answer your email as soon as possible. Sometimes if I'm in the middle of a trial, I may not be able to respond to your question immediately, particularly if you're asking me some complicated problem. But basically I would be able to respond to your question within 2 or 3 days. And normally if I'm free, meaning I do not have to go to court, then usually I can respond to your inquiry on the same day. So if you have any question in relation to land law and conveyancing, feel free to drop me an email. One thing that I have to discuss with you before we start the lecture is about the arrangement of the breaks. If you have studied with me previously, you will know that I will allow students to have the option either to have 2 breaks or 1 break. If you want to have 2 breaks, then we will conclude the lectures at 10 sharp. But if you want only 1 break, then we can end the class at 9:45 so that everybody can go home a little bit earlier. So it's up to you. It's all right with me, whether you want 1 break or 2 break, or you can have 1 break for 30 minutes, if you like. This simply a choice of you. If you want to go home a little bit early, then we will have only 1 break of 50 minutes. So any say, make it simple. Any objection that we only have 1 break of 50 minutes? No, okay, that's a deal. So we'll have only 1 break, 50 minutes, and usually we will have the break at 8:15 to 8:30. Okay, land law and conveyancing. Well, those who have studied obligation with me would remember that in the first class of obligation, I told you obligations was the most difficult module in year 1. And unfortunately, I have to repeat the same thing today, because land law and conveyancing is the most difficult module for year 2. Difficult because there are a lot of legal jargons that we have to learn, and a lot of new concepts, which are different from what you believe you understand about land law. So the problem is, without understanding all these legal jargons and concepts, it's not possible to understand land law. Well, for obligation contract, for example, the concepts are very straightforward, and you come across those concepts and contract, in fact, from your daily experience. But for land law, unless you are involved or you have been involved in some of the legal transactions. Say you purchase a property yourself previously, you may not have idea about, for example, concept of ownership of land. So in this first lecture, in fact, I don't expect we can finish this lecture within this evening. We may have to continue until the next lecture on Wednesday. We try to introduce to you the most important and fundamental concept of land law that you have to appreciate in order to understand the theory and practice about land law and conveyancing in Hong Kong. But not to scare you, but just tell you the fact. You may have heard there is an exam called Overseas Lawyers Qualifying Exam in Hong Kong. So if you are solicitors in England, in Australia, or other common law legal jurisdiction, if you want to practice in Hong Kong, you are not required to study LLB and PCLL again. But as long as you have 3 years practical experience in your own jurisdiction, you can simply sit the Overseas Lawyers Qualifying Exam administered by the Law Society. And in that exam, there are 5 papers, and one of them is land law and conveyancing. And in the past few decades, this is the paper in which most students fail. So land law and conveyancing is difficult. And I heard some lawyers, foreign lawyers, actually try to apply for exemption of this course and promise the Law Society that they will not handle any land law as long as they allow them to practice as a solicitor. To avoid this exam altogether, of course, it is not possible for you to have this choice. Okay. Start with some question. What does it mean when I say I own a piece of land in, say, Yunlong, Tai Po, or whatever, or even on the Peak? I own a house with Clouds Bay. I own a flat in Tai Fu Shing. I own a Rolex watch, and I own a bank account in HSBC. Now, all of this question has the word own. But are they saying the same thing? When you say you own a piece of land, what does it mean? When you say you own a house, what does it mean? When you say you own a flat, what does it really mean? I own a watch, you own a watch, or whatever chattels, car, for example, and I own a bank account. What do you actually own? Now, start with the dichotomy between personal properties and real properties. Now, personal properties, sometimes the technical term for that is personalities. Personal property include what we call shows in action. This CH is pronounced SH, not K. CH could be pronounced as SH or K. For example, characteristic, then the CH is pronounced as K. But CH also can be pronounced as SH. For example, schedule. Sometimes people will pronounce it as schedule. But in any event, that is the pronunciation, shows in action. Nowadays, in fact, it has been replaced by this word, things in possession, in many contexts. But what does it mean? Things in possession. It means all movable object, movable. That is to say, they are not attached to certain land or certain other things. Or shows in action. Now, movable object, physical object, of course. Shows in action is also personal property, but they refer to some intangible, no shape, you cannot touch it. Intangible rights, which can be enforced by a legal action. But in the law of property, they are classified as personal properties. Now, what are the main difference? Of course, we cannot go into detail, but in short, show in action, in possession means the ownership of this thing, movable object, of this object, can be transferred by delivery of the property. So the ownership of this, say, this pointer can be transferred to you, from me to you. Well, assuming that I'm the owner, I can just give it to you, and then you may receive the ownership of this chattel. Say a watch, iPhone, computer, all these are chattels. Show in action or thing in action, usually no physical body, therefore intangible, and ownership usually cannot be transferred by delivery of some physical object, but can be enforced in a court. For example, bank account, a debt, and insurance policy. When you say you own a bank account, you may have a passport, but can you just give the passport to your friend, to your parent, to your lover, and say, well, I transfer my bank account to you? No. But if it is an iPhone, you can just, oh dear, take my iPhone. I give it to you as a gift. This is the main difference. When we say something is show in action or thing in action, it is actually referred to some legal rights that you can enforce. And of course, the places or arena for enforcement is in court whenever there is any disputes. Likewise, insurance policy, for example. You subscribe to an insurance policy. You cannot just pass that piece of document. Maybe you sign and the insurance company sign on that document to prove that you have purchased an insurance policy. But that policy cannot be transferred to another person simply by giving the other person that particular document. Now, from the legal perspective, personal property or personality creates rights to an action in person name. An action in person name means an action against the person. And in effect, say for example, if someone stole or took your pointer away, and you can sue him, and that guy could choose to pay damages. Remember what is damages? Damages are monetary compensation, money. If you took this pointer away, and if I sue you in court, you can simply say, oh, okay, I pay back the money, but you can keep this one, rather than return the property to the dispossessed owner. Real property, R-E-A-L, real, does not mean genuine. Okay, this is the Latin phrase, Latin word. It actually refers to thing again. Real property or realties, sometimes just like personal property, it's called personalities. Real property is also known as realties, include land and certain rights in land. And real property creates rights to an action in rem. Now, action in person name is for personal property, and for real property we have an action in rem. That means action against the thing against that property. Now, real, don't mix it with the word real as the common word that we know, meaning genuine. Real means res, and it means rem or thing. So action in rem, sometimes we call it a real action. That is misleading. If you think that it means a genuine action, no. It means the wrongdoer may be ordered to return the property to the dispossessed owner in addition to paying compensation. So for personal property, if someone take your property without your permission and you go to court, you can only have an action against that person, and that person can simply pay money as compensation to your loss. But for real property, it is not simply an action against the person. It is an action against the thing, the property itself. So if, say for example, someone occupied your flat without your permission, you can go to court and ask for an order to force that person to leave, to give the land back to you. And just like personal property, there are two main kinds. There are two main kinds of real property. Now, against some technical term, corporeal hereditaments, or tangible or physical property. Corporeal, the word corpse, C-O-R-P-S-E, dead body, that means body actually. So it is a hereditament, some rights that can be inherited by your descendant or by anyone that you pass it on to him. So this is some kind of inheritable interest which has a body, physical body. For example, a land, a piece of land, physical land, and the attachment to the land. For example, if there are trees, there are flowers, there are grasses on the land, all these are corporeal hereditaments. And the other, just like show in possession and show in action. Show in action is intangible, right? And we also have incorporeal hereditaments. So these real properties is intangible rights. Now, easement, this is a term that you have to understand because this is a hot topic for examination. But at this stage, we do not go into detail about the law of easement. But basically, it means if you own a piece of land, you may have the right to use the land in your neighborhood, even though you have no interest on that land, but you can use it in a defined way. Okay? Rental income is also incorporeal hereditament. You rent out your flat to the tenant. You get the rental income from the tenant. This is, incorporeal hereditaments. Of course, we are not talking about the cash he gave you or the tenant gave you. We are talking about the rights to collect the rent from him. Okay? So basically, the most general classification of property in this world under common law. Personal property and real property. Under personal property, we have two things. One is tangible, that is thing in possession or show in possession. The other is intangible rights, and they are known as show in action. On the other side is the so-called real property. The real property, we have corporeal hereditaments, some right which has a physical body, and incorporeal hereditament. This is some intangible rights. Now, just have a general idea about this first, and then we'll come to each of them later. Okay, look at this question. A rents a farm to grow flowers. So A is the tenant to the farm. The lease is prematurely terminated because A has failed to pay rent. Now, you may have this experience. If you rent a place, if you fail to pay rents, your landlord will kick you out. So the tenancy agreement may be terminated before it expires. Now, this is actually what happened in this question. But when that lease is terminated, there are many flowers still growing in the field. Now, A asked the landlord to pay him compensation for the flowers. The landlord says A has no rights to claim for the flowers because the flowers are part of the land. You begin to feel puzzled. Why the flowers become part of the land? Why A would not just, cut all the flowers and take them away? Now, if A do that, he may be guilty of theft. Now, look at the definition for land. Now, in this lecture, or in the landlord conveyancing that we have studied in Diploma Legal Study, the definition for land comes from Conveyancing Property Ordinance. Now, Section 2 of this ordinance defines land to include 4 things. Land covered by water. Now, buy-sell land means dry land, but under the legal definition, even the land covered by water is also land. Now, if you have studied or come across some land property or legal document about land property, you may have heard of this term called marine lots. Lots usually are referred to different land. Marine lot means the landlord covered by sea. So, land covered by sea or by water, if it is a pool, for example, a pond, it is also land. Under this definition, any estate, right, interest, or easement over land. Now, this word is a headache. I think at least you should learn the common term, common meaning of this word estate. Sometimes we refer to housing estate, some housing. But if you remember, in your obligation, you should have learned estate, meaning refer to properties left by a disease. If you die, sorry, touching wood, you have property left behind. We no longer describe those property as property. We call that estate, your estate. And in land law, we have a few more meaning. One of the meaning refer to certain interest, certain rights. Easement, again, we have talked about that already, and we'll discuss what is an easement in detail later. So we're talking about some incorporeal predicaments, some rights, some interests. The whole or part of an undivided share in land and any estate right, interest, or easement in or over the whole or part of an undivided share in land. Now, you begin to puzzle. What are the undivided share in land? Now, we'll go to this concept in detail in the later lectures, but for now, it refers to your right. If you are an owner of a flat, for example, in a multi-story building, I can tell you, you do not own that particular unit. Say, for example, you purchase flat 1A of second floor of certain multi-story building, you thought wrongly that you are the owner of flat 1A. I'm now telling you, you do not own flat 1A, okay? I will explain later why you do not own that flat. But your right in that multi-story building is what we call an undivided share of that building. Now this is the important point that I want to point out. Things attached to the land or permanently fastened to anything attached to the land. So it's not just the land itself, which is defined as land, but anything which is attached to the land. So flowers are attached to the land by the roots, right? So they become part of the land. And there's a tree attached to the land. You fastened something on the tree permanently. Maybe you fasten a lamp there. Then this lamp also becomes part of the land, because under this definition, things permanently fastened to anything attached to the land is also land itself. Therefore, later on, you will be very careful when you sign a tenancy agreement with your landlord. You must have expressed provision in the tenancy agreement in relation to things that you are going to attach to that particular premises. Otherwise, they would become land. And by the time your tenancy expires, you have to leave those things there, unless the landlord allows you to take them away, because they are part of the land, and your rights to occupy that land would expire by the time your tenancy agreement expires. Or if you take, say for example, your mount a very big television set, you know, the most modern or the latest model on the road. When you move out, you say, oh, I have to remove this television set. Now, unless you have agreement with your landlord, don't do that, because you may be committing theft if you remove the television set without the permission of your landlord. Why? Because things attached to the land becomes land. And your right to occupy that particular premises expire when the tenancy agreement expires. You have to leave those things to the landowner. Of course, that's why when you enter the tenancy agreement, you must have agreement with this tenant, with this landlord, saying that, well, anything that are attached to the land, I will take away. If he agree, of course, no problem. Now, 1 and 4, land covered by water, things attached to land are physical objects or corporeal predicaments. And 2 and 3, about the estate, interest, rights, etc., refer to intangible rights or incorporeal predicaments. And undivided share refer to the share of land under co-ownership. You know, we'll explain this concept in detail, I think in our lecture 4 or lecture 2, I can't remember exactly. Easement, you know, the right to use the land belonging to your neighbor. We already briefly talked about that. Now, why I say our definition of land is based upon Cap 219, that is a Conveyance and Property Ordinance. Because in other ordinance, the definition of land may be different. For example, in this particular ordinance, Limitation Ordinance, Cap 347, land is divided to include, this is verbatim reproduction of the definition from the ordinance. Lands include corporeal hereditament. They use this term. That's why I had to introduce this term to you. And when charges and any legal and equitable estate or interest therein, including an interest in the proceeds of the sale of land held on trust for sale. Now, I will explain to you all these words later. But except the foresee does not include any incorporeal hereditaries. Now, so other than this, they would not include any, for example, say it did not, it includes, a legal interest therein in the land. So, for example, easement is not included in this particular definition. Now, don't worry if you don't understand this definition, because I cite this one just for illustration purposes. You don't have to know limitation ordinance, fortunately. Now, rent, under the definition in Cap 347, includes what we call rent charge. These are also copied from the ordinance. Rent means 租金, or rent charge means 租費. What does it mean by rent charge? It means any annuity or periodical sum of money charged upon payable out of land, except a rent service or interest on a mortgage on land. You don't understand what it's talking about, right? Don't worry, don't have to remember this. Proceeds of sale of land held under trust for sale. Well, we will come to the concept of trust for sale later. But proceeds of sale, of course, means the money. You sell the land to the purchaser. The purchaser pay you money. These are the proceeds of the sale of land. Now, the definition of land is under in this chapter 347 is wider than the common meaning of land. That we base upon in Cap 219. So we are using this definition. Don't have to worry any different concept or difficult concept in Cap 247. Okay. So we have a very basic understanding about the definition of land. Now, if you forgot anything I said just now, after this class, don't worry. But the one thing that I really wish that you could remember is about the definition of land in section 2 of Cap 219. Land includes land covered by water, interest, estate, right, easement over a piece of land, undivided share of land, and particularly things attached to land and things fastened to something attached permanently fastened to things attached to land. Okay, now what are the laws in relation to land law and conveyancing? First of all, we have to look at this ordinance called Hong Kong Unification Ordinance. Actually, it comes from the basic law. After 1st of July 1997, when Hong Kong became Hong Kong SAR, what are the law governing Hong Kong? The law previously enforced in Hong Kong, previously before the 1st of July 1997. What are they? That is the common law, rules of equity. It should not be rules or OF. Rules of equity, ordinances, subsidiary legislation, and customary law. Now, customary law is also a very complicated concept in Hong Kong. It deals with land in the new territories. Luckily, in our syllabus, the customary laws is not really the focus. And I will just briefly touch on that. later. Anyway, all these which have been adopted as the laws of Hong Kong SAR shall continue to apply. Therefore, when we study land law, we have to study the common law rules, the equitable rules, ordinances enacted to deal with laws of Hong Kong, any subsidiary legislation, and in fact, the Chinese customary law. But fortunately for our syllabus, this is not that important. Now, because after 1997, new territories actually are not so different from Hong Kong. But before the 1st of July 1997, new territories are a different part than Hong Kong Island, for example. Because the new territories were leased to the British government for 99 years. So, whereas the Hong Kong Island was ceded to the British government forever, in theory, forever. So the English people, English government, deal with the Hong Kong Island and in fact the land south of boundary streets, different from the new territories. And so they have a particular ordinance to deal with new territories ordinance. And section 13 of this ordinance said that in any proceeding in the High Court or the District Court in relation to land in the new territories, the court shall have power to recognize and enforce any Chinese custom or customary rights affecting such land. Okay, this is the provision of section 13. In other words, on the face of it, the ordinance allowed the court to apply Chinese custom to land in the new territories. And later on, there were litigation about lands in the new territories. Court explained this section. He said, shall have power actually means courts have no choice but to recognize and enforce any Chinese custom affecting such land. Now, again, law has been changed in 1994. But before 1994, for example, if you are what we call an indigenous villager, that is to say, if your father, great-grandfathers lived in the what we call the recognized villages in the new territories in the year 1898, you are classified as indigenous villages of the new territories. If so, if you are a man, congratulations, you enjoy a lot of rights over your sisters. For example, if an indigenous villager, of course he must be a man, a father, say for example, died, and he has land properties in the new territories. If he left no will, I don't know whether you learned about the law about succession. You know, if you have a will, of course, your estate, remember what are estate? Estate are property left by deceased, would be distributed according to your wills. But if you do not have a will, then we have an ordinance called Intestate Ordinance. That means in means no. No will ordinance. Now, under this ordinance, the estate will be distributed according to the section in this ordinance. For example, the spouse, no matter man or woman, will have a statutory sum. And this statutory sum at the moment is 500,000. So if say we are now talking about men, right? If the father died and he had property less than 500,000, every cent will go to the wife, the surviving wife. And if he has, property more than this value, then the wife will get this sum first, and the remaining will be divided between 50% to the spouse and 50% to the children. Okay. Now, what if the father, the indigenous villagers, have a piece of land in the new territories? If this guy is not an indigenous villager, he's someone live in Hong Kong and he has a piece of land, both the children, son or daughters, can have a share of the land. But if he's an indigenous villager, if the land is a new territory, then the children would become son only. Only son would inherit the piece of land. What about if this guy had only daughters, no son? Unfortunately, the land will go to the nephews of the father, rather than the daughters. It was only in 1994 that we have changed the law so that nowadays both daughters and sons would have the rights to inherit the land from the father. No. Now, that, because it comes from what we call in English the Qing Code, in Chinese Dai Qing律例，淨係仔可以承繼嗰啲地嘅啫。Now, Section 13 saying that court shall have power, and it was interpreted to mean court have no choice but to recognize and enforce any Chinese custom affecting such land. So, in the past, before 1994, there was the new law passed by the Legislative Council to cancel that particular Chinese custom. The court cannot do anything but to say, oh, sorry, girls, you have no right to inherit the land from your deceased father. Fortunately, we do not have to deal with the Chinese custom that much. Otherwise, it would be another difficult chapter for you. Okay. Let's look at the concept of ownership of land. A rents a flat from B. Now, of course, in Hong Kong, the common practice is that A, being the tenant, has to pay B, as the landlord, a sum equivalent to 2 months' rent as deposit. Of course, during that tenancy period, he has to pay monthly rent as well. But on top of the monthly rent, he has to pay in advance 2 months' rent as deposit. I don't know whether you have think about this situation or come across this situation before. Before the lease, before the tenancy expired, B sells the flat to C. Now, of course, A still have to pay rent, but now A has to pay rent to C. Upon the expiry of the lease, A asks C to return to him the 2 months deposit. It's natural. You say, I pay the deposit to B. Now the lease or tenancy expires, so I want to get back the deposit. C refuses and asks A to get it from B. I don't know whether you come across this kind of situation. While you are, renting a place, your landlord sold the property to a third party, and that third party refused to pay that deposit to you, ask you to find the previous landlord. It happened not infrequently in Hong Kong. Okay, we'll come back to that concept a little bit later, but have this question in your mind. Now, we are talking about ownership of land. So we want to know, what does it mean when I say I own certain property, and how can I demonstrate to the world that I own this property? If it is some chattel, some show in possession, physical possession usually indicates ownership. You use your iPhone, usually it means you are the owner of the iPhone. Shows in action, physical possession usually not possible. How can you possess your account? Well, you may have a card, you may have a passport, but that is not your account. For real property, physical possession, or occupation, to live in the piece of land, to live in a fact, it usually only an indication of possessing certain interest in the land. It does not necessarily mean you are the owner. Of course, for example, you are a tenant, you may occupy the land, but you are not the owner. So physical occupation of the land is not the indication of ownership. So how can we know what we actually own? And to ask a more fundamental question, can you really own a land, or a piece of land, a house, or a flat? Now, in order to make things, you can say, simple or complicated, the land law, the common law, has invented a system to show ownership of some land or rights to the land. We usually do not say ownership of land. We use the term called proprietary rights or interest. Proprietary interest, proprietary rights. Basically, they mean really the same thing. We call that proprietary rights in land or over land. And this proprietary rights refer to rights that is attached to the land but not attached to the person. You must have the appropriate proprietary rights to a land in order to own it. So again, this is a term that you must know in land law. Now, in the common law system, we do not say we own a piece of land. We say we have the proprietary right to possess the land. So this is, of course, just like over in contract law, possess has a special meaning here. Possession includes both physical and exclusive possession of the land. Physical possession means you can occupy the land, you can move in the land and live there. Exclusive possession means that other than you, no one can enter the land without your permission. So your right is exclusive against the world. Exclude others from entering and possessing the land. Now, when you have the proprietary right to possess the land under the common law legal system, this right to possession can be converted into a right to receive rent from the land. That is actually how a tenancy or a lease is granted by the landlord. I have the proprietary right to possess this piece of land. In our daily language, I own this piece of land. I can, for a period of time, transfer this right to my tenant so that the tenant can have this right to possess, meaning that he can physically live there and exclude all members of the world from entering this land. Now, of course, this tenant has to pay a price for that, and the price we call it a rent. So he gives me the rent and allow him during the lease or tenancy to physically possess my land. Now, of course, this is only a temporary arrangement. When the tenancy or lease expire, I can get the land back. That is, I get the proprietary right to possession back. Now, during the tenancy, this right to possession already given to the tenant. Then, what right do I have? The technical term is reversion right. The landlord get a reversion right. So, in a diagram, you can ownership equal to proprietary right to possession. So this is the right of the landlord. And this right to possession can be part with to a tenant, so that this guy would get the proprietary right to possession for the duration of the lease or tenancy. Now, during this duration, the landlord will have the reversion right. Reversion, that means the land will reverse back to him at the expiry of the lease. And of course, he can collect rent from the tenant for passing to him the proprietary right to possession. So, this proprietary right to exclude others has two levels of meaning. The first level is that the right, this proprietary right, operates against third party who has no right over the land. In other words, anyone in the world. And if you have this proprietary right to possession, you can eject any trespasser. Trespasser means anyone who enters the land without your permission, who comes on his land without permission, and he has also a right not to permit others to enter his land. That is the right to possession. And this is also a right which operates against third party who has proprietary right over the land. Now, you can now appreciate that this proprietary right could exist in different level. So, give you an example to illustrate this concept. I'm a tenant. Under the tenancy agreement, I can stay on the land 2 years and can pay the landlord a deposit of 2 months of rent. The landlord promised to return the 2-month rent to me upon termination of the tenancy agreement. So that is the common arrangement in Hong Kong. You pay 2 months rent as deposit, and if you do not breach any of the terms of the tenancy agreement, the landlord would return the deposit to you upon the expiry of the tenancy agreement. Now, that is it. Actually, I'm explaining the question a few slides earlier. My landlord then sells to a third party the land that I am occupying. If you still remember this concept, privity of contract, I cannot enforce the tenancy agreement against this new landlord because he's not a party to our tenancy agreement. So he has no privity to this contract. But since this tenancy agreement confers the proprietary right to possession to me, the proprietary right is a real property attached to the land but not to the person. This proprietary right gives me the right to enforce the tenancy agreement as long as it is not expired against the new landlord, so that the new landlord cannot enter the land without my permission, as long as the tenancy agreement is not expiring. So, as a result of the proprietary right that I possess as tenant in relation to the land, the new landlord is bound by the tenancy agreement signed by the previous landlord. So we are not relying on the tenancy agreement. We are relying on this proprietary right. So I can stay on the land until the tenancy agreement expires. However, in that agreement, in that tenancy agreement, not all the promises confer a proprietary right on me. And, for example, the landlord's promise to repay the 2-month deposit, that remains to be a show in action or some contractual right. That has nothing to do with the land itself. Therefore, it remains to be a contractual right. Now, if it is a contractual right, then the doctrine of privity of contract would apply. I can only enforce this promise against the original landlord, but not the new landlord, because the new landlord has no privity to the contract, to the tenancy agreement. Now, you can more or less know why land law is complicated, because we have so many things, grouped together when we deal with land. But at least you should know the right to possession is some real property. It is attached to the land. Whereas other contractual terms are show in action or thing in action. They are personal property. You can only enforce it against the person. So in the previous question, when A enter into a contract with B and B sell it to C, upon the expiry of that tenancy agreement, unless C is willing to pay you back the deposit, you have no choice but try to locate the whereabouts of B. Otherwise, you would have no deposit returned to you. In fact, later on, you will also understand your right to a flat in a multi-story building operates similarly as what I just said. It involves proprietary right as well as contractual rights. Okay, so let's have a little pausing moment for you to get some digestion of what I've said so far. Land law is difficult because they are operated in an entire different mindset, different from contract law and the common daily experience of us. When we come to land law, we have to learn all these technical rules. But I've tried to make things easy for you. But of course, I understand that it may not be easy for you to understand. In the first or second lectures, I have the same problem with you when I sit before the professor about land law, learning English land law. When I was studying LLB, equally puzzled. I don't know what he's talking about, until I myself also read the textbook, etc. But just remember, land is misleading because land means four things, and is the physical dry land, any land covered by water, and things attached to the land. All these are land, and it also refers to some incorporate hereditament, some rights and interests over the land. And the most important right is this proprietary right to possession, because this gives you the right to exclude the entire world from this piece of land that you are occupying. And usually we call that ownership. And the interesting thing is that this so-called proprietary right to possession can be transferred temporarily to someone called a tenant, where while you yourself as the landlord keep that reversion right. So this right will come back to you. That's why it's called reversion right. And at the same time, you can collect rent from this tenant for passing on to him the proprietary rights to possession. All these are very abstract, I understand that. But later on, when we goes to individual legal concept of law, we will have to make use or apply this concept to those situations. Now, we just learned that land covered by water is also land. Look at this particular question. A lived in a small house with a garden in typo. Okay? A's neighbor, B, likes to fly an unmanned aircraft to take photos in the neighborhood. Now, this has become a very common practice in Hong Kong. People just fly some unmanned aircraft and take photos or just look at the scenery. The aircraft often flies over the garden of A. A wants to stop B's aircraft flying over his garden and small house. Advise A. Can they do that? The unmanned aircraft does not touch the land itself, just fly over it. No, it cannot. Because the proprietary right, this proprietary right to possession, extends to the airspace above the physical land. So one more concept, not just water cover the land. The airspace over and above the land also belong to the land owner. And at common law, the owner of land used to own also the airspace above the land up to the atmosphere, and the soil below up to the depth of the earth. So the saying goes like this: the owner owns everything up to heaven and down to hell. So if you own this piece of land, from this piece of land you draw a line up to the atmosphere, all this part belongs to you, and all the soil underneath go to the core of the earth belongs to you. That is the common law concept of ownership of land. This proprietary right to possession is such a great right. Now, so in theory, if there's an airplane fly over your house, this airplane actually infringe your right as landowner because it fly over the airspace. And such infringement gives rise to an action in trespass or nuisance. That is to say, you can go to court and get an injunction to prevent someone from entering your airspace, not just entering your land, but the airspace. But of course, that will make life impossible in the modern world. Therefore, the modern view is that an owner only owns the airspace up to a height necessary for the reasonable use of the land. And in fact, in many countries, there is aviation legislation to prevent landowners from taking action against aircrafts flying over the land at a reasonable height. Now, if it's low enough, you still can protect your right over the airspace. But if they fly, say, 1,000 miles, 1,000 meters above your land, then you cannot prevent them from doing so. And in Hong Kong, we do have that legislation, Civil Aviation Ordinance, Section 8.1. No action shall lie in respect of trespass or in respect of nuisance. In fact, they agree it is trespass because they enter without your permission. That is the meaning of trespass. By reason only of the flight of an aircraft over any property at a height above the ground, which, having regard to wind, weather, and all the circumstances of the case, is reasonable. So, in Hong Kong, our law recognizes your right of the airspace up to heaven, actually up to heaven. But they just create this ordinance to allow the aircraft to fly over it. No action shall now that prevent you from taking any action. Now, that is a common law. It was first recognized by this case, Easement and Skyview General Limited. Now, by the way, you should have a little bundle of cases. I have, collect the cases in my slides, and I give you the facts of the case and the outline of the ratio for easy reference. Now, in this case, actually it was about a crane, A building was constructing, this was a crane over and above the owners. Skyview General. Well, this is a company that operates aircraft to take air photo. I don't know whether you have heard of this aerial photos. Usually in new territories, the government would take every photo from time to time. They just fly an aircraft over new territories and take photos, believe. And this is the Skyview General Limited company operating those aircraft. And Burston said, well, you took photo even high from my house, but you are infringing my right. So we sue him, sue the company, and the courts, without the aviation legislation, that even nowadays common law recognize that your rights could only be up to a height necessary for the ordinary use and enjoyment of your land and the structures. You did not, you actually own the airspace, but you cannot prevent others from using it at the same time. And in another case, the court actually affirmed that invasion of airspace amounts to a trespass. In a landlord, trespass is an important concept. If you enter another person's land without permission, that even that person suffer no loss, he can go to court and sue you. You can see the abstract of these cases for detail. Now, another cases, some trees growing on the neighbor's garden overhung into the defendant's land, and that defendant just cut the branches. Well, if you cut branches of trees belonging to your neighbor, it amounts to criminal damage. But since they overhung onto the garden, it is an invasion of the airspace, and the court affirmed that cutting the branches over the person's land, the airspace of the person's land, is not trespass. It is his right to enforce his ownership of the airspace. And this is one of the cases in which the court recognized the rights of landowner over the airspace. And this is actually the case conducted by me, representing the plaintiff company. Now, that is a case in which we're talking about some small houses. In that case, there's a big piece of land. Okay, it's my client's land, and this is the land of the small houses. So they built quite a few small houses around this land, but they built a wall. They want to separate their land from our land. But when they build their wall, part of our land was being occupied. Even worse is that one of the small house was built close to the boundary, and the small house has a balcony, 2.5 meter pointing out, 2.2 meter of the balcony intruding into the airspace of my client's land. So I represent my client and go to court, require them to dismantle the wall because they include part of our land, and also ask the court to make an order that 2.2 meter of that balcony has to be destroyed because they intruding into the airspace of my client's land. And
was entitled to repossession of the land trespass, including in order that part of the balcony that occupied the airspace of the land be removed. Because, as owner of the land, I own also the airspace, not just the physical piece of land. Okay, maybe this is a very good time for us to take a break, even though 2 minutes earlier than 8:15, because we are going to a new topic. Okay, 15 minutes break.